Good afternoon. I'd like to welcome each of you to our pre-termination hearing. My name is Scott Nelson. I am currently serving as the chair for District 7. We welcome each of you and thank you for your attendance. We're going to start exactly on time because we have a superintendent here and I don't want to be marked truant. So we're going to fulfill our obligations as we need to. We'd like to welcome Ms. Damiano and Ms. Medart. Thank you very much for being here. We will begin our meeting by, I am speaking into the microphone as close as I can, so if you can't hear me, I do apologize. We will begin our meeting by reciting the Pledge of Allegiance, and I would invite all of you to stand with us and recite the pledge. Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, we'll try to make this as loud as we can. Before I begin reading our prepared statement as we begin our termination event, I would like to publicly thank my fellow colleagues on the school board. I am appreciative of the time and effort that they have spent in preparing themselves. As you can see in front of me, literally hundreds, if not thousands, of pages of documents have been prepared and given to us, and we have reviewed them diligently in preparation for today's events. We do recognize the sensitive and maybe even contentious nature of this, and we're grateful for everyone's attendance. This is a formal proceeding of the Grants Pass School District Board and an opportunity for the board to consider matters before it. Although this meeting is open to the public, no public comments will be allowed at the hearing. The board is hearing this matter based on solely the records and reports before it, which, until this hearing, have not been made part of the public record. We hope that everyone in attendance will act civilly and avoid disruptive behavior. We ask for no protesting or signs to be allowed inside the building. If any person disrupts the proceedings, they will be asked to leave. If the meeting becomes disorderly, we will excuse the public from in-person attendance. In such an event, the meeting will continue to be available to the public virtually on Zoom. The Oregon Legislature has established a process and the standard for dismissal of probationary teachers and administrators. Oregon Statute 342.835(1) provides, the district school board may discharge or remove any probationary teacher during a probationary period, for any cause considered in good faith sufficient by the board. The probationary teacher shall be given a written copy of the reasons for the dismissal, and upon request shall be provided a hearing thereon by the board, at which time the probationary teacher shall have the opportunity to be heard either in person or by a representative of the teacher or administrator's choice. The hearing this afternoon is a pre-termination hearing to provide the employee with due process, including hearing the reasons for dismissal and providing the employee the right to respond and be heard before the board determines whether the employee should be terminated. The employee has requested an open hearing, and therefore this hearing is being held in a public session. This is an opportunity for the public to hear the proceedings. It is not an opportunity for the public to participate in the hearing because the board is to consider the matter based on the records, reports, and arguments provided to them, and not based on public opinion or other factors. Public comments received by the district related to this matter will be provided to the board after this matter has been heard and determined. The public may provide comments to the district to be forwarded to the board or directly to the elected board members through official email or email addresses. The board does appreciate input from the public on matters of concern, and we do review public comments at an appropriate time. The board has been provided a report and materials collected by Bill Landis from Pacific Consulting and Investigations, an independent investigator who reviewed complaints against the employee and prepared a written report. The employee and attorney for the employee were provided with the opportunity to provide the board with additional written materials or documents to review as part of these proceedings. The procedure tonight will be as follows. The district administration will brief the board as to the reasons for the recommendation of dismissal. District administration will be provided 10 minutes to set forth the reasons for the dismissal. The employee or her attorney will then be provided 30 minutes to respond to the administration's recommendations for dismissal. The administration shall then have 10 minutes to reply to the employee's response. The board, following that 10 minutes, will be provided an opportunity to ask questions of the employee and the administration. Depending on the time allotted, we will spend 30 to 45 minutes on that portion. Upon conclusion of any board questioning, the hearing will then be closed. After a motion is made and seconded, the board members may deliberate, and then a vote will be taken, and that will conclude the board action on this agenda item. Are there any questions from the board members on the proceedings outlined? At this time, the district's attorney, Nancy Hungerford, will review the reasons for termination as set forth in the superintendent's recommendation to the board and will be given 10 minutes. Nancy.
Thank you. Board members, we appreciate your service, and particularly I know that you have had volumes to review, materials that have been generated by the investigator who did an independent investigation of this matter, and then following that, recommendations from the district administrative staff. Let me start by just saying that we have a process here that is bounded by state law, not just in its dismissal proceedings, but also in the overall relationship of school boards to the state. Oregon's Constitution provides that the state shall provide a system of common and adequate schools free to the public. And that has been delegated to the legislature. Years ago, the legislature decided that school boards, local school boards, would be responsible for some aspects of that job, but it is very much a state system. And so some of the things you're going to hear about today here in terms of policy and so forth come from the state. Guidelines in some cases, but in many cases, very definitely requirements that the school district must meet and its employees must meet. And then the board, as working for the district, is responsible for adopting local policies to carry that out. We'll be talking about those local policies here and how this particular employee of the district has violated those in the minds of the superintendent, also Shara Ely, the initial reviewer, and also the investigator, Bill Landis. So the local school board, you sitting here, have the responsibility to enforce those policies that you've adopted. And maybe you were not on the board when they were adopted, but you still have that requirement to enforce those policies. And your administrative staff does likewise. Among those policies that Ms. Damiano has been identified as having violated are a number of those that have to do with the use of work time and district facilities and equipment for matters that are not permitted under the statute or the policy. So let me review those for you. First of all, the district has adopted a policy GBG. That policy has gone through a number of iterations. The policy that we're relying on here was the one in force and in effect in March of 2021 when the events occurred that are the subject of this hearing. Now, that particular policy refers to electioneering and campaigning, but it goes beyond that. And in this particular case, I want to emphasize those portions of that policy that go beyond just campaigning. Because the policy states, and it starts off by emphasizing the fact that district employees do have rights to free speech. but those rights are in their private lives outside of their work time. The policy says that they have a right to choose either side of a particular issue and support their viewpoints as they desire by vote, discussion, or persuasion of others. But such discussion and persuasion will not be carried on during the performance of district duties. And that's logical. Taxpayers don't particularly want to have their public employees spend time that they, invested for the instruction of students on private political or persuasive matters. Now, there's another regulation that has been adopted in the state that this district is also required to follow, and all of its employees are, including Ms. Damiano. One of those is a TSPC rule. It's a rule that states that the ethical educator in fulfilling obligations to the district may not use the district's or school's name, property, or resources for the non-educational benefit without approval of the employees, the educator's supervisor. In addition to that, there's another policy that the district has adopted, and it's a fairly recent one. It has to do with the use of the district's internet and network facilities and staff. And all employees are required, and Ms. Damiano did take a technology acceptable use training last September when she entered the district. And included in that was a statement that she had to endorse. I will not use the district network or school equipment to promulgate personal or political opinions. So those are some of the policies that we are relying upon here. These policies and regulations make it clear that the public employees like Ms. Damiano have the right to engage in such activities on their own time by voting or activities to persuade others. They have freedom of speech during their private lives. That is not what this is about. They are not entitled and may not use time paid by public funds or use district equipment or to promulgate personal or political opinions using district property or resources for non-educational benefit. Now, the independent investigator gathered information and concluded that Ms. Damiano had violated those policies and regulations that I have mentioned. Ms. Damiano admitted to using district resources, and the investigation confirmed that she used district computers and emails, school property, and Google Docs to share or communicate regarding the iResolve video or to respond to those individuals who commented on that video. And she used that to advocate her position, both to district staff and to persons inside and outside the school district. Repeatedly during the video, Ms. Damiano asked viewers to lobby their U.S. senators about a bill in the state legislature, in Congress, and to contact state representatives and legislators about Senate Bill 52 in the state legislature. Those constitute personal or political opinions, and thus, by using district resources and time, she violated these policies that I have outlined for you. The recommendation to dismiss makes it clear that the basis for termination would not have been sustained had Ms. Damiano not chosen to use District 7 facilities, email, equipment, or supplies, and her time, all paid for by taxpayer dollars, for her iResolve campaign. Secondly, there's another policy or part of policy GBG, and that says that an employee must not fail to designate that viewpoints she's advocated were her own personal viewpoints, not those of the district. And that's a specific statement out of that policy. Indeed, Ms. Damiano failed to abide by that policy. She starts off the video by using her position in the district to validate her message. Hi, I'm Rachel, and I'm an administrator, assistant principal in Southern Oregon at the middle school level. A simple Google search identifies the speaker as Ms. Damiano and the school as North Middle School in Grants Pass. Why did she do that? Why did she have to mention the fact that she was an administrator? She did that to authenticate or validate or to persuade, but she used her district position in a way that was not allowed by your policies. Not surprisingly, after the video was aired during the spring break, the district received numerous complaints from local citizens and other staff who thought and concluded that the video was telling them that the positions stated by Ms. Damiano were district positions. And that's why that rule exists. That rule is to make sure that any communication of a position in private, whatever, has to say, I am speaking for myself. That was not done in this video. There was a drop-down message added later, but that was not present when that video was first placed before the public. In addition to that, the board has adopted a policy, GBAB, that requires district employees to use social media in such a manner as to prevent substantial disruption in the school. By posting on the iResolve video, website using district time and equipment, Ms. Damiano violated that policy too, and did create substantial disruption, including student protests, staff and citizen complaints, and divisions among staff. Given the findings of the independent investigator and the conclusions of administrative staff, starting with Sherry and then going to the superintendent's level, a pre-termination hearing was offered by the superintendent. Ms. Damiano chose not to participate in that. She chose not to use her opportunity to have her viewpoint or her arguments raised before this recommendation for termination was made. So she's here today in another opportunity for a pre-termination hearing to raise those issues that she wants you to consider. But she had a prior opportunity to do that before this recommendation even went any further.
Nancy, this has been 10 minutes. Would ask you to wrap up. Thank you.
Let me finish then quickly. So under Oregon's fair dismissal law, as you've heard, the probationary administrator, whether educator, whether an administrator or a teacher, may be dismissed for any cause deemed in good faith sufficient by the school board. In making this decision regarding the dismissal of Ms. Damiano, you should carefully listen to the recommendations of your administrative staff who are responsible for the day-to-day operation of District 7 schools. They have very valid concerns about a probationary educator who has failed to follow district policies, who's created disruption that's seriously impacted the community and staff. There are no requirements for second chances or progressive discipline in the law for probationary educators. Those are reserved for those people who have gone beyond the 3 years and have attained contract status. The probationary period is a testing period. Ms. Damiano has failed that test. She's failed to demonstrate the basic requirement to work in a public school system, to follow the policies that your board has enacted. Because of that, the board should accept the recommendation and vote to dismiss Ms. Damiano. Thank you.
Thank you. At this time, we will turn our attention to Ms. Damiano, and you will have 30 minutes to present your case before the board. Thank you.
Thank you, and thank you for this opportunity. Hopefully everyone can hear me, so I will speak up. Last year, I was wooed to Grants Pass School District from a neighboring district for an open middle school assistant principal position. District 7 sought to hire me for my reputation for bringing innovative ideas to the table and for my strengths in organization and creating clear procedures. As educators, we thrive on collaboration because it encourages innovation and leads to growth. The school district has tried to convince you that the ideas Katie and I brought forward were a, quote, campaign of a political nature. And in fact, their entire argument hinges on a misreading of Oregon Revised Statute 260.432, subsection 2, which states, and I quote, "No person shall solicit influence or give money, service, or other thing of value to promote or oppose any political committee or to promote or oppose the nomination or election of a candidate, the gathering of signatures on an initiative, referendum, or recall petition, the adoption of a measure, or the recall of a public office holder during working hours. Neither Katie nor I did any of these things. We didn't ask our fellow employees for money or services, nor did we seek to promote or oppose a political candidate or a ballot measure. ORS 260.432, subsection 2, also states that it does not restrict the right of the public employee to express personal political views, which was also validated by Ms. Hungerford's argument earlier. That is all Katie and I did here. We are as free to express our beliefs concerning gender identity education policy with coworkers as they are to express their extreme dislike of Donald Trump or to discuss why Oregon State has a better football team than Oregon, or vice versa. And let me clarify that all statements I make today are my own opinion and not that of the district's. In response to the allegations against me for this hearing, I will begin by looking at an overview of the sustained allegations and then look at each of them in greater detail. First, Grants Pass School District fabricates a term, a quote, campaign of a political nature, non-sanctioned, and you'll see that in the letter from Superintendent Kolb, that is not defined in the Oregon statutes and is therefore of no force or effect. The district does not have a role in sanctioning the private activities and staff. The district cannot redefine terms to hold staff to a more stringent, strict, or oppressive standards that are imposed by ORS 260.432. This was also stated in Ms. Hungerford's argument earlier, that board policy is defined by state policy. No ORS standard or statute can infringe upon an individual's civil liberties and constitutionality protected activities or rights. Grants Pass School District supports their fabricated term, utilizing ORS definition of, quote, political campaigning. However, ORS 260.432 defines political campaigning, which makes it absolutely clear that the alleged activities are not political campaigning. ORS 260.432 specifically protects lobbying, also as stated in Ms. Hungerford's argument that it was lobbying throughout the video, as being an allowed activity and not being political campaigning. Voicing opinions regarding pending or proposed legislation is not political campaigning. Rather, expressing personal political views, which ORS 260.432 specifically allows for. Personal points of view or perspectives expressed on social media, regardless of whether they are opposed by other district staff or the community, cannot be regulated by the district, nor are the reactions of others the responsibility of the person expressing his or her ideas. As the Supreme Court affirmed in Manahoy Area School District versus BL less than a month ago, for the district to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. That particularly applies to off-campus speech, whether of students or of employees. As such, all allegations lack credibility and are completely without merit. Having looked at an overview of the allegations, I will now look deeper at each of the sustained allegations and detail why they sufficiently lack the merit or credibility to be upheld. 1, and this is quoting directly, I believe you have a copy as well from the letter from Superintendent Kolb. 1, quote, you use district facilities, equipment, and supplies to conduct personal business of a political nature. This is determined to be a violation of board policy GBG. Grants Pass School District inappropriately attempts to redefine, quote, political campaigning to be personal business of a political nature, or, quote, campaign of a political nature, which are both fiction and of their own creation. If Grants Pass School District had a separate policy regarding personal business, quote, of a political nature, and if it, or does not have one, and if it does, it should be somewhere in the employee handbook, so its employees have notice of and comply with such a policy. Such a policy would likely be an infringement on your civil liberties and constitutional rights, given how they are characterizing the fictional term, a campaign of a political nature. ORS 260.432 is the governing statute regarding the factual definition of the term political campaigning. As such, it acts as the dictionary in defining such a term as political campaigning. The ORS itself addresses the only 4 times in which the term political campaigning applies, each of which are clearly defined earlier in the statute in 260.005. These are, and I believe I gave you a copy of the administrative handbook that goes along with ORS 260.432. 1, for initiatives, referendum, and recall petition efforts as soon as it is filed with the election filings officer. That does not apply to Katie and I's speech. 2, ballot measures referred to the ballot. Again, does not apply to Katie and I's speech. 3, political candidates. Does not apply. And 4, political action committees. Our video also does not apply. Our video and movement do not align with any of the aforementioned applications of the ORS, and therefore we do not meet the definition of, quote, political campaigning. As such, we are not in violation of board policy GBG at any level. 2, bullet point 2 on the letter from Superintendent Kolb. Quote, you use the district network for transmission of the related materials and information of these political campaigning efforts. This is determined to be a violation of board policy IIBGR-AR. Allegation 2 is a moot point because our activities were not political campaigning under ORS 260.432, as I previously stated. 3, you use paid district time to engage in the efforts to support and promote a campaign of a political nature. This is determined to be a violation of policy GBG. It was not stated in this allegation that it would be of personal, it was of political nature. This is a moot allegation because, as previously proven and demonstrated, there is no such term, quote, campaign of a political nature in the board policy, as you will see, and furthermore, we do not engage in political campaigning according to the Oregon Revised Statute. But regarding a workday, GP School District is trying to construe that a salaried employee is on the workday 24/7. The bulk of the creation and promotion of the iResolve movement and related materials was done during personal time, including the entirety of the creation and promotion of the video being done during spring break. However, ORS 260.432 limits the workday to performing, quote, official activities in the capacity of your job. It also provides that activities while at the workplace, in this case school, can be private at personal times, such as before or after school, during breaks, or during lunch. As such, Grants Pass School District cannot claim that it can engage in viewpoint discrimination 24/7 for private activities that they, teachers, members of the community, etc., simply do not like, while also arguing that all activities, quote, at school, are work-related and precluded. It is easily argued by that time spent, which was de minimis, on any email sent or received regarding iResolve at school was on our own personal time, lunch, etc., particularly given all the time we put in beyond a 40-hour work week requirement. Under political campaigning, which this is not in our case, so the email issue is moot, it allows receiving political email at work and even forwarding to personal email. I recommend that the board look closely at the email portion of the admin handbook that I've given you for ORS 260.432. In terms of allegation 4, quote, when posting the iResolve movement video, you failed to identify that your political viewpoints were yours personally and not representative of the district. This is also determined to be a violation of board policy GBG. The policy in its entirety states, quote, on all controversial issues, employees must designate that the viewpoints that represent on the issues are personal viewpoints and are not to be interpreted as the district's official viewpoints. Stating that you are a, quote, private citizen or not on the video is moot because it was not a political campaign. We are not speaking at a public event during our work time or speaking for a committee, and we never even inferred that we were speaking for the district. In fact, nothing in our video identifies us as Grants Pass School District employees. We said we were from Southern Oregon, which is a pretty large place, stretching from the Pacific Ocean to the Idaho border and encompassing at least 14 middle schools alone, not to mention private and charter middle schools. We didn't wear any North Middle School gear or any other clothing that identifies us as district employees. Only because someone who saw the video recognized us as a district employee and chose to complain about our speech did the fact that we even work for Grants Pass School District come to light. That indicates that we took care to make it clear that we are not speaking for the district. Allegation 5, quote, your personal use of social media very much created a substantial disruption to the school environment. This is determined to be a violation of board policy GCAB. The actual policy, GCAB, reads in its entirety of this section, quote, staff members while on and off duty will treat fellow employees, students, and the public with respect while posting on social media websites in order to prevent substantial disruption. In essence, the district is trying to claim what is known as, quote, heckler's veto. Heckler's veto would say that a person speaking is responsible for the reactions of those that hear the speech, and therefore the government can restrict that speech. But in the landmark Heckler's veto case, Termination versus Chicago in 1949, the majority opinion by Justice Douglas stated, quote, "A function of free speech," he wrote, "under our system of government is to invite dispute. Speech may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. The court determined that it was unconstitutional for the city to restrict the priest's speech because others had chosen to react in a negative way. In a similar vein, Katie and I cannot be held responsible for the response of others. And furthermore, our speech was nothing but respectful, loving, and tolerant towards all students, all parents, and all community members. Moreover, the timing of the alleged disruptions came nearly a week after posting our video and website, and all the cited emails from the community members in your extensive reports from students and from former students were sent to the district after the superintendent himself requested that the community reach out to him, thereby directly inviting a disruption. His email states, quote, "Please contact me or our Human Resources Director, Danny Huber-Cantola, with any additional concerns or needed support." The timestamp for all of the emails cited in your report, not from the original complaints, as well as all of the media coverage also cited to support that it was a substantial disruption, came only after Mr. Kolb sent his email and only after we were put on leave. This would indicate that the reaction by others and the reaction by the district itself is what caused the disruption, not the posting of our video, our social media, or our website. School boards, I would ask you to reflect on the message you are sending to the students and to our community. You have an opportunity to model what we endeavor to teach our students daily: tolerance. In having the conversation as educators, this is our job to model to our community how we have this discussion, and we do not cancel each other. We have it in a respectful, tolerant, and loving way, and that is not what has happened here today. We were not given an opportunity to discuss with the complainants when it originally happened. We were never able to have that respectful conversation, and it was elevated to this level. I would ask that the school board model for our community what we ask our students and our community members to do every day. Thank you.
Thank you very much. Nancy, you have 10 minutes to complete your remarks.
Thank you. Unfortunately, most of Ms. Damiano's response is based upon an assumption that the district is relying upon ORS 260.432. That's not what the letter of dismissal says, recommending dismissal says. It mentions district policies, and I've already told you that those policies go beyond what is provided in the statute, and they address particularly the use of district equipment and district time. So it would be another matter, and indeed your investigator said this matter would never have come forward as a recommendation, findings of inappropriate action, if Ms. Damiano had not used district resources and district time. Now, salaried employees maybe are not on district time 24/7, but you have an administrator here who has responsibilities that go beyond the regular workday. But in any case, the investigation, and you've had a chance to read that investigation report, it went over 100 pages. The investigator concluded that this employee had used district time, had used district equipment, had used district internet equipment and resources. And in terms of what this says to the community, you know, I think that the very worst thing it says to the community is that people who happen to be employed by the school district can have advantages to get their word out and to use equipment and district time and paid time that other people don't have. And that's exactly what we are trying to avoid with this policy. Not to set school people out with having special advantages to contact the community, but instead to insist that they act on their own time with their own resources, just like everybody else has to, if they want to make political points or persuasive points, if they want to persuade others of their case. Now, there's a contention here that the Supreme Court has addressed this issue, And I think that that is an overreading of a recent decision by the Supreme Court, which had to do with student speech. So I don't believe that the Supreme Court has addressed this. In fact, most recently, the Supreme Court denied review of a case out of the circuit courts in which the issue was held to the interest of the student who had contended that their rights were being violated by having individuals who did not want to address them by a name that they had chosen. That action by the Supreme Court leaves standing court decision that indicates that it was a violation of that student's rights when teachers refused to use a name that he was comfortable with because he was going through a transition. Now, sorry, thank you, not here. So that's the court case that you should be looking at. The Supreme Court refused, decided against taking that case. That leaves the lower case decision. And yet, one of the two main points of the materials that were placed on this video was that teachers shouldn't have to use the name of a student that the student preferred, that they would be able to exercise that right. There is no First Amendment right of a teacher in the school building to choose a name for the student beyond that what the student wants to be used. That doesn't exist because they are not entitled to First Amendment rights in their pursuit of the district's interests in teaching students, and the district makes that decision. And in fact, the U.S. Department of Education has suggested that that's the way that educators need to behave. That's something that is directly contradicted by the material that is placed on that video. As to the policy that is regarding to speaking for the district, the obligation is on the individual to make that clear that they're not speaking for the district, not the other way around. And as Ms. Damiano says, we made it clear that we are not speaking for the district. That is not true. That is not true. If you've listened to that video, you know that it is not true. The investigator found that it was not true. So to now coming up to say that, well, we made that crystal clear, is kind of afterthought here on the part of these educators who didn't consider that part of the policy. They did not follow that part of the policy. They've also contended that, and Mr. Damiano rather, has contended that they can't be held responsible for the fallout of this. And if they were acting in their private sphere only, there may be more substance to that. But when they chose to use district resources and time, and there is no de minimis exception. In other words, the policy talks about any time, use of any time. And it's written that way because it is important to have those boundaries. As far as the timing coming a week after this matter was posted, that is also not true. There were impacts that arrived and started very shortly after, and it was during spring break. And there were administrators who were absent during spring break, but immediately upon returning to the district, they heard about complaints and concerns by parents and by students based upon what they heard in that video. So it's not like the district waited or chose to ignore those complaints until such later time. They immediately, on March 31st, which was 2 days after after spring break was over, met with Ms. Damiano, and at that time made it clear that they were going to be doing an investigation, and there was at that point suspension. So I think a lot of the points that have been made by Ms. Damiano here are based upon an assumption that we're going forward solely on this accusation of violation of ORS 260.432. It doesn't say that in the letter. And in fact, your policy that was adopted, GBG, the policy that existed in March, identifies other matters that can be a violation, and they were violated. they all revolve around this fact, this matter, this concern, that public employees do not have rights to use district time, equipment, internet access to gain entree to others. They have to play by the same rules everybody else does. But by using their position, by choosing to identify themselves as being administrators, teachers in Southern Oregon, again, it's very easy for the public to identify which school district that is. They could have identified themselves as being simply public citizens, but they didn't. They chose to use the district's name to validate their message. And in so doing, they invoked the district's concern about their actions, as well as the fact that they used resources that are not available to other members of the public, resources that are paid for by the public to advance their cause. Thank you.
Thank you very much, Nancy. At this time, we will open up to questions from the board members to either the attorneys and the administrators and/or Ms. Damiano. So, are there any questions from the board members? You've all been left speechless, I take it. Gary, I know you have a question. Go ahead.
Actually, I don't.
No questions?
No question.
I do.
Todd?
Member Neville from the board. Yeah, my question, and maybe it's just clarification. I hear two opposing arguments. One from the administrative side that says that Mrs. Damiano was denied opportunity to meet at a pre-termination hearing prior to this. I thought I heard from Mrs. Damiano that you were not able or allowed to have a discussion. I'm a little confused. Maybe those aren't related.
Yeah, I can clarify that from my statement. So in my statement, I was referring to in typical fashion, when we have a concern or a complaint come in, you would be allowed to talk to the complainant. You try to resolve at the lowest level possible, right? It's how we work with, as an administrator, right? It's how when teachers, when there are concerns against teachers or even other students, we try to work with it at the lowest level possible because that's how we as society want to deal with things, right? We want to make sure that we're going through all of the avenues to resolve an issue. In this case, we weren't. We were not allowed to talk to the other complainants. We weren't brought in to have a discussion with them and to have a reasonable and tolerant conversation around what their concerns were and address those specifically. We were just put on leave.
The policy that is being referred to is undoubtedly KLAR, and that one has a public complaint process, but it does allow for individuals who are complainants to choose not to enter into that kind of a conversation. And I don't know all of the specifics, but I do believe that many of the individuals who brought forth these complaints were not interested in meeting with the individual. At that point, the responsibility was on the district to do the investigation, to come to conclusions. So we cannot impose upon people who complain that they have to meet with someone who they do not have that desire or willingness to meet with. What we can do, and what we did do, was to make clear what the nature of the complaint was, and to allow for this, Ms. Damiano to respond to that. First, to the investigator. Very thorough investigation, obviously time for her to express her viewpoint. But in addition to that, there was a pre-termination hearing that was offered with the administration. Ms. Damiano chose not to hear those complaints and respond on that occasion. She has waited until this point, and she's given you a very legalistic kind of response that basically says that since they weren't campaigning on the basis of an elected office or some sort of a constitutional provision that was on the ballot, that their actions are beyond your concern and their actions are beyond your ability to control. That's not true because this policy goes beyond ORS 260-432. And the other policies that I mentioned go beyond it as well. They do deal with specifically the use of district wherewithal, district's internet service, district time, that their salaries that are paid for. And the investigator found, and I've not heard it contested here, but the investigator found that that was happening, that those resources were used to construct the video, to respond to individuals. We know that if you've read the investigator's report, that there were opportunities that were used by these individuals to contact other people or talk to other people on staff time. And so it's not a matter where all of this activity is off the clock. It used district resources and time, and that is the reason for the recommendation for dismissal.
Gary?
Does the district have a policy that talks about when we put people on paid administrative leave? In other words, at what level of something do we pull the trigger to put somebody on paid administrative leave?
The Oregon Revised Statute says that the superintendent of the district, for any cause that the superintendent believes is warranted, may place an employee on paid administrative leave. These employees have never lost a day of salary. They are still on paid administrative leave until you make this decision. But that is a decision that is totally in the hands of the superintendent.
So we have no policy.
There is no policy because the statute delineates that responsibility as being the superintendent.
Okay.
Yeah.
Gary?
Well, so I have some comments, but I don't really want to do that until we're done with questions, I guess I'd say.
So based on our outline, we have an opportunity to ask questions. Then that will end the pre-termination hearing. We will then entertain a motion from the board. Once that has been seconded, we have an opportunity to discuss before we vote. And so that may be the ideal time to provide some commentary if you would like.
Okay.
So, Brian.
Thank you for being here today. This is a lot of information to take in, so I just wanted to get clarification on, I thought earlier you mentioned something about political action committee. Could you speak to that a little bit?
Yeah. So again, under ORS 260.432, right? One of the bullet points for when it applies is if it is a political action committee, which Katie and I are not a political action committee. You have to actually apply to be a political action committee for that to apply to you, which we're not.
Thank you.
Yeah.
Todd?
Another question I have. I understand the message was changed on iResolve to either comply or to give a better understanding of the opinions, how they were expressed. Why were those changed?
Yeah, thank you for asking. So the district met with us met with me the Wednesday after we returned from break, so about a week after the video was posted. And there was concern expressed that we weren't explicit enough in how we had not claimed that we were the district, and so we added a disclaimer at the very end to comply with what the district had asked us to at that time. So it's been up since a week afterwards.
Thank you.
Debbie, I see you inching towards the microphone. Any questions from anyone else? I do have two questions, if I may. I noted in your statements that you were reading, you did state that the bulk of the work that you did with regards to this activity were done outside of school. Does that mean that some of that was done at school?
So I was referring to from the report, what was listed as the evidence against us was 11 emails total. Of the 11, 6 of them were done on spring break. 5 of them were sent to me, not by me. and one of them was a forward. So I wanted to respond and make sure that I wasn't inaccurate in what the district had used as evidence. Again, we don't believe that it's political campaigning and a violation in the first place, but I did want to address the 11 emails that they bring up as evidence against us for using district resources and time.
Okay. I don't know if this is appropriate, I guess, and so if it's not, the attorneys can stop me. I am curious to know if you were to return to school, if the district was to not side with the superintendent, I don't know if the public has been privileged to see all of the complaints and the emails that have come on the opposite side of the spectrum, but there are a lot of hurt individuals, both teachers, staff, and students, as well as parents. How do you go about rectifying some of that damage? I know that you have, I watched the video. I did not think that there was a lot of anger or vitriol. I do think that unfortunately in our society, things get blown out of proportion. People are looking for offense. But nevertheless, offense has been taken, bridges have been burned. How do you, as an assistant principal, return and help correct that?
I appreciate the question. I think that gets to the content. So initially, that gets to the content of what we were talking about, which isn't the allegations against us today. However, I do want to address that in education, again, it's our responsibility to model how to have tolerant conversations, how to be respectful of others. So I would hope that if there was hurt or if there was anger or frustration, that we could come to the table and have a conversation where we're loving of one another, where we're respectful of one another, and we are able to talk that through, because I don't believe in anything that I've done at the district or in my career has ever been out of a mean spirit or something that would harm someone on purpose. And so if there was a feeling of harm, then we'd be able to have those conversations. And I think that being offended is different than disagreeing, right? So we need to be able to make that distinction that if you disagree, let's have a conversation. And if you feel like it harmed you in some way, again, in our society, we want to model that. How do we have that conversation? Because in full transparency, that does not happen in the public eye, right? In news media and in the politics, it's all about the sensationalism of the story, right? Who harmed the worst? Who said this inflammatory thing? But that's not on a day-to-day basis, right? We, in our lives, need to be loving of everyone and have a conversation. That does not mean that we agree on everything. It just means that we can do it in a respectful way, which we feel we've done. So I would hope that the district would be able to help support that belief and be able to bring people to the table for that conversation.
So a follow-up question to that then is, very likely in the future we will be asked to refer to students based on the pronouns that they would like to be asked, and as a vice principal you will be asked to help educate and enforce that with your teachers. Is that something that you feel that you'll be able to do faithfully if you're asked to do that? Or, as I read through a number of the conversations that you had, that does seem to be a very contentious point that was argued vehemently for lots of reasons. But as you talk about respect and collaboration and working with individuals, I see this as being a potential sticking point in the future if you were to stay. How do you personally handle that, and will you be able to do what the district is asking of you to do as we work with employees or students who wish to be addressed in certain ways?
Again, I believe that that's a question in regards to the content of my speech, which is not why we're here today. Right? We're here for the allegations of the board policy that I allegedly violated. And so in speaking to that, I would rather have that conversation separately, because that's not why we're here.
And I completely understand. That's why I said if this is inappropriate, you don't have to answer. I think for me, I'm trying to look at, how do we rebuild what is a wounded community right now, as we can hear, the protest on either side going back and forth. And so this has become, I think, probably much more than what you anticipated when you started going down this road. And I'm sure it is a lot more than the rest of us anticipated as well.
Yes, so. And if I can speak to that, I believe that conversation absolutely needs to happen, right? How do we, as a district that is in the center of this town, that is an amazing community. I moved into this community a few years ago, and I love it. And I love the people, and I want to be able to have a conversation that brings us all together. I think that's a conversation after the board makes a decision on whether I've actually violated allegations or not. And so I would love to have that conversation and be a part of that conversation after the decision.
Okay.
If I may be heard on that point.
Yes.
Because I believe that your administrative staff, I'm speaking for them on this occasion, I think that they have justifiable concerns that matter of public's dealings with Ms. Damiano are irreparably harmed. There will be people who will not be willing to respond to any of the nice sounding platitudes we're hearing here because there has been injury made to them in their minds. And that injury has been advocating that their child will not be addressed by the name that the child wants to have used, or even if the parents want to. That's part of what this whole I Resolve matter is about, that their child will not be able to use a restroom facility that their child is comfortable with. And those are parts of what they're advocating here. So, you know, if they're prepared to say that they're going to use the name that the child wants to have used, even though that's directly contradictory to what they're saying here, it still remains something that the administration can justifiably believe that they're going to have to monitor, that they're going to have to maintain some problem solving, and they're going to have to continue to deal with the fallout of this I Resolve video. And when people knew that it was not done by district permission, they have to deal with an administrator that they may not trust. And then there's staff, and there are staff in your school district that are not prepared to deal with someone who used this opportunity with district time and resources to broadcast a message that essentially those staff members find very disrespectful. Because this is a probationary administrator, there is no obligation for you to engage and put that load upon your administrative staff. As I said, there are no obligations for using any progressive discipline. Probationary status is just that, it's a trial period. Maintain that this employee did not pass the test of that trial period. And for any one of a number of reasons, you could choose to terminate a probationary employee's employment. And we're urging that you do so because there is that fallout, there is irreparable harm done in the parts of relationships. And it's not so easy as we're being led to believe here that all will be fine after people have conversations.
May I respond to
Chair
that?
Nelson, we're starting to drift off into some of the other aspects of, I guess, the activity that occurred. And at least from what I've been told prior to the meeting, we were going to try and stay focused specifically about this termination hearing. If we're going to start talking about the pronouns and future actions of the district and how that all works, we're going to drift to a place I don't.
Sure, I appreciate that, Gary. You're right, and that's why I ask if we're getting too far astray. I'm happy to have the attorneys tap me on the shoulder. It was part of the investigative report, and so from my standpoint, it is important that I understand those aspects. But I am done. You may, Ms. Medard, respond, and then if there are not any other questions, we will continue with the ending of our termination hearing. So,
I appreciate that. So in terms of even what Ms. Hungerford said earlier about terminating a probationary employee, the words sufficient cause and good faith were used. And in terms of good faith, right, I was brought here under the allegations in the email and in the note from Superintendent Kolb. The allegations that were discussed by Ms. Hungerford were found to be not substantiated in the report. So to bring them up as an allegation, as a reason to fire me, I believe would not be in good faith for this hearing.
And again, from a legal standpoint, good faith, that portion of the statute has been interpreted by the courts, and it simply means that it's not being done for any illegal purpose.
Okay, thank you. Any further questions by the board members? Okay, at this time, the pre-termination hearing is now concluded. The board will proceed to act upon the recommendation, which has been given by our superintendent to terminate Ms. Medard. We will begin with a motion from any board member, and then a second, and then we can proceed with a discussion. Sorry, Ms. Damiano.
Thank you.
Thank you for that clarification. I've got both names written right here. It was the first one. I apologize.
It is confusing. We're also both sitting in front of you.
So I'll entertain a motion from a board member. Brian?
I move to accept the superintendent's recommendation for termination of Ms. Damiano.
Thank you. Do we have a second?
Pardon me, I didn't quite hear that.
Sorry. I move to accept the superintendent's recommendation for the termination of Ms. Damiano.
I will second that.
So the motion has been moved and seconded. I will now turn the time over to the board for a discussion. Gary, we'll let you start first.
As board members, we represent the public for Grants Pass School District Number 7. There are multiple issues that the public has strong interest in at our schools that are in focus today. The policy question about restrooms and locker rooms, the policy question about rights of employees, the policy question about if the district is presenting information fairly or if the district is indoctrinating children. These are important community issues. However, our issue today is for the board to determine if we approve of the superintendent's recommendation to terminate employee Rachel Damiano. This is a much narrower topic than what the public would like us to address today. However, we have to follow our policies and the laws of the state of Oregon. We have heard two sides of the issue from the district and the employee. In addition, we have numerous documents to give the board a complete record of what happened. From my occupation as an engineer, I have a very linear, sequential method of reviewing and solving problems. Please bear with me as I lay the foundation for my conclusions. These are some definitions that need to be understood for the following information. Email, like normal mail, has senders and receivers. People cannot be held accountable for emails that are sent to them. Specifically, any email sent to a District 7 employee that is not work-related, by definition, cannot be a violation of our policies because they are not responsible for emails sent to them. Assumptions and perceptions versus facts. Just like the game of Clue, where the object of the game is to declare the facts of the crime by information gathered, knowing a fact that was not disclosed by assumptions and perceptions is not the same as the fact being disclosed. Policy IIBGA, AR, Electronic Communications System Acceptable Use Regulation. Quote, students, staff, board members, volunteers, district contractors, and other members of the public may be permitted to use the district network for personal use, in addition to official district business consistent with board policy, general use prohibitions, guidelines, etiquette, and other applicable provisions of this administrative regulation. Personal use of district-owned computers, including internet and email access by employees, should be limited to breaks and after hours, end quote. Defining an administrator is very important to this hearing. An administrator has much greater responsibilities and, unlike a teacher, has broad latitude to set their schedule and accomplish their work. The downside to that latitude is their responsibilities often require work outside the normal workday. Report findings that were used by administration to find grounds for termination. Allegations. A, use of district facilities. The conclusion of the investigator is an error. The policy cited, GBG, is referencing a very technical point related to ORS 260.432. The investigator and the administration failed to properly apply ORS 260.432, which is related to using public resources on one side of a political campaign, such as a school bond. All other political speech is protected. I cannot emphasize enough that the Oregon legislature has made a very bright line between what is acceptable and what is not. It has been mentioned that the district could have more restrictive speech policies than the state. The idea that a local political entity could be more restrictive than the state on First Amendment speech is not valid. B, use time during a workday for political. The conclusion of the investigator is an error. The investigator, having erroneously concluded that this was the type of campaign in ORS 260.432, applies too strict of a standard to Ms. Damiano's workday. Given the flexibility and responsibility of administrators, no activity during the workday would violate district policies unless it interfered with performance of their duties. C, failed to designate the viewpoints. The conclusion of the investigator is an error. This is a quote of policy GBG 42721, staff participation in political activities. When engaged in off-duty activities on all controversial issues, employees must designate that the viewpoints they represent on the issues are personal viewpoints and are not to be interpreted as the district's official viewpoint, end quote. This quote by the investigator was the subject of debate and concern by the board when the policy was adopted. The example given during the discussion was that an employee could not wear a Grants Pass High School shirt or insignia and give a video interview that might cause people to think that their opinion was the district opinion. Ms. Damiano was clearly not wearing any district insignia, clothing, or other identifying symbols from the district. No comment made by Ms. Damiano verified the fact that she was a district employee. Only by using information outside the video and website is it possible to make the linkage between Ms. Damiano and District 7. D, use social media and public websites. This allegation is a difficult one to decide. Policy GCAB 39/2021, personal electronic devices and social media staff, says, and this is not a quote, this is my short version, says employees will treat people with respect in order to prevent substantial disruption in school. The social media was respectful. The disruption to the school is real. It is not clear to me that the disruption was caused by the social media post by Ms. Damiano, but actually may have been caused by social media posts by others. If that were determined to be the case, there may be cause by the district for disciplinary action against other employees and students. I want to pause here for emphasis. If this is a disruption to the school, then other posts in opposition are also disruptions to the school. There is no free pass because the other side said something first. Because that is not the reason for this hearing, I will leave that to a later time. Posted confidential information about a student. The conclusion of the investigator is in error. Policy GCAB 3921, personal electronic devices and social media staff. In reviewing the social media post in question, I find this statement about a student at the 540 mark. I had a female student. She then was on a journey of exploring what her gender what is her gender identity. She had made a request to identify as a male, and the request came for to go by he and him and to change their name. So I was sent an email by a staff member saying this student is making this request. I let the student know that we are in support, that we will support this, end of quote. There is no identifying information here. The investigator makes much of the fact that there are people that can identify this student, but that is only because they have other information and, as in the game of Clue, can deduce who the student is, not because of any confidential information, and it's not because any confidential information is given in the social media. F, created a bias incident. The conclusion was not sustained by the investigator or used by administration as a reason for this hearing, and I will not address it further. After reviewing the record, this board member finds that there are no violations of policy. In addition, I find that administration failed to follow policy KL. The 6 complaints by employees should have been handled at the building level. The email complaints should also have been handled at the building level. My recommendation is for the board to not uphold the recommendation for termination and to direct administration to follow policy KL. Unfortunately, this recommendation will prolong the disruption to District 7, but it is the right thing to do. Ms. Damiano's actions may not be technical policy violations. However, I will point out that with her greater responsibility comes an expectation of better judgment. She should understand the need to follow the policies and directives of the district and to be a role model and a leader using good judgment to bring credit to District 7. That's the end of my statement.
Thank you, Gary. Any other discussion from our board members? Our board meetings would be a lot shorter if we have a full audience, I've noticed. All right, well, Gary, I do appreciate your comments. We have heard from, I believe, everyone with regards to the policies and the procedures and potential violations and not. And we appreciate your presence here today, and for all of those who have come to support you and for all of those who are here supporting others who may feel that they have been mistreated. We will proceed to our roll call vote unless there is any other discussion that anyone would like to make. Gary.
Well, I did have one additional item from the information that was gathered here today, and that related to probationary employees in District 7. Every year in March, we essentially go through the list of employees that are being rolled over in their contract, either for probationary or for contract. And I have noted a number of times that we have probationary employees that have plans of assistance and various other supports in place. I have not been aware of one where the district presented to us that this employee should just go, essentially, you're gone. So in this instance, I find it a little abrupt that we're terminating without essentially the support systems that we typically give to teachers.
Have we ever had an employee or a probationary teacher who has, I guess for lack of a better term, created such a stir in the district previously?
So there were none of those.
Okay. I mean, I think, that is the point. I think that's one of the reasons why we're here, is because this is a unique situation, and just because no other probationary teachers have been dismissed, this is unique in its scope and in the involvement of the community. So,
And it's unique in that we didn't follow policy KL also.
Well, I don't know if it's appropriate to have the administrators comment on that. Is that part of what we may or may not do in these proceedings? These are questions that would come back to the policies that were followed by administration.
Hey, repeat the question for me, because it's very hard with this mic system for me to hear
Sure.
across the room, so.
So the assumption, maybe accusation, is that the district did not follow policy KL and how it handled the complaints as they came up through the junior high school, and that the complaint should have been centered around the principal, and he should have investigated the complaints as they came forward and then brought later towards the district, and that area is saying it was not followed as far as the procedure.
No, there's no relationship between those two. The board may move forward if they conclude that it's not a matter that they want to have perseverate and fester in the district with the relationships. There is no requirement that you go through certain steps when it comes to the termination of a probationary employee.
So the district did not violate policy KL.
I do not read the district as having violated that, because that requires a willingness on the part of two parties to engage. And I'm not aware of all of the specifics, but I am aware of some where there was not that willingness because of the nature of the disrespect that people felt this video pretended.
Okay. Brian?
We had a board meeting on Tuesday, and Member Brownell said something during that meeting. She said, "We have an obligation to make sure all students are as safe as possible." And I've been thinking about that since Tuesday, as it relates to our decision here. And it's hard for me to see how allowing this administrator to stay will not make some group of our students feel less safe in our schools, whether that's real or their feeling. And so our top priority is to make sure all students are as safe as possible. And so that's why I am accepting the superintendent's recommendation.
Todd?
Yeah, I would like to just make the comment that, and I don't know if this goes along with what Gary is saying, but my impression and what I feel moved upon to say is that I don't feel that due process was handled on the lowest level before it came to this, where it's at now. I'm not sure if that even lines with what I've heard. I have had issues, by the way, hearing because of the echo effect. Everything. I'm getting the context and the content of what's going on. But I felt moved to say that it does not appear, from what I've read and heard, that based on good faith, that due process started at the lowest level.
So I think that does bring up another question, and that is, what was the due process that came up through the junior high? So as these complaints were created, I know that we have information here from Tommy Blanchard, who is the principal, as well as some of the other administrators, as they sat down to meet with Ms. Damiano. Do we feel that it was unsafe to proceed with further investigation at that level, or did we need to ratchet this up to the district level and have the superintendent intervene? I think that is what I'm hearing from the board, is that they don't feel that there was due process given at the appropriate level, and that this was elevated right up to the superintendent, and then they were placed on administrative leave from the get-go. So what reassurances does the board have that we did go through those steps, or the reasons why we felt, the district felt that they needed to then move on or move forward with a more aggressive approach?
Well, I'll just answer part of that question. You know, basic due process at this stage of the process is the opportunity to know what the charges are, what the evidence is, and the opportunity to respond, and nothing more than that. So they know what the charges are. I have 100 pages of investigative notes here that find that indeed there was far more use of district time than is being acknowledged here. District resources. That's your investigator, independent investigator. There's no requirement that you go through the steps that are being identified here. We have met the basic due process requirements.
Okay. Well, Todd, I think I will answer as I read through all of these things. I think that there has been some due process. The principal of the middle school was involved, as well as Danny, who is the HR director. I noted that they met with them to discuss that, and we have the transcripts of those conversations that they had. And so I know that there has been a process that was begun at that initial time. And then I think from there, so I guess what I'm saying is I do believe that there has been some of that due process taking place, and we do have those records here in front of us today.
Thank you, Chair.
Okay, well, Tanya, we will now call for a roll call vote, and we will tally up our votes and have a decision. I vote in favor of the superintendent's decision.
Not in favor.
What are you voting when you say that? I voted not in favor of what? Of the superintendent's recommendation. To terminate.
Cliff, do you understand the vote? The proposal has been to accept the superintendent's recommendation to fire Ms. Damiano.
What I want to vote this right here, to be followed. I'm not sure which side that is.
I don't know how to help you, Cliff. The vote is to terminate or not to terminate. So would you like them to be fired, or would you like Ms. Damiano to be fired or not to be fired?
He's having trouble hearing. Chair, he's having trouble hearing, and so he might need some more help with that, more accommodation.
Sure. Brian's here. He will help you hear. Okay, we will ask Bill Ransom to assist.
Somebody's got it. True. I was going to suggest Sharon Nelson do it, but. Well, I thought he was going to.
Thanks, Brian, for being willing, and thank you for sitting down.
Sorry. Closer. You were closer. Get over there. Nobody can see over there. Who's looking at the wireless? 2 seats. I apologize. I thought I could do better. I would like to support the motion that was made by Brian and seconded by Debbie.
Thank you, Cliff. Tanya?
Yes. I vote non in favor.
Yes.
No.
Tanya, the total was?
The vote is 3 no, 4 yes.
Okay, thank you. So with that, then, Ms. Damiano will remain a member of the school district.
No, it was 4 yes. It was 4 in favor, 1
terminated.
I'm sorry, I must not have heard correctly. One more time. So 4 no, 4 yes, and 3 no. Is that correct?
Not,
Sorry.
I'm terminated, was the conclusion.
So the recommendation passed. I'm sorry. Thank you very much. I'm getting as old as Gary is over there. I'm not hearing very well, so thank you. So that concludes this termination event. We will reconvene at 5 o'clock for the next hearing. Thank you.